Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. We are on week 3. Today, we're going to talk about strong utility patents, the claims, the drawings, the descriptions, and avoiding pitfalls. We have 4 episodes, and if you'll stick with me today through 1 hour, we are going to cover about the utility patent application and the things that you can see. Now, of course, your patent attorney is going to draft the patent application, but it's good for you to understand some of the things that are critical to avoid mistakes. If your patent attorney is not up to date, you want to know that as soon as possible. There are a lot of things that change all the time in patent law. Whenever a new case comes out that says the person lost the patent battle because their patent application said this or did this, then that's ammunition for the next patent battle, patent lawsuit, the person defending against the patent to avoid infringement or invalidate your patent. So that's where these come from, is court cases as well as best practices. So the first of the episodes today is about the patent claims. So it's like building a strong bridge. Patents can be thought of as like a bridge. In STEM competitions, small bridges are built by students and then tested with weights to see which bridge will hold the most weight before breaking. Now, when a patent gets issued, it's not really weight tested in this way. The patent examiner does do research, and we strongly recommend that you do your own research as well prior to filing the patent. But that's all the weight testing it is what could be found that is already out there that would potentially make it so your claims are not valid. So it's the research. Now, when a patent is litigated, then there's a lot more research that typically goes into it, a much heavier weight. And they, instead of spending 10 hours on research, they might spend 100 hours on research and trying to find patents or prior publications that show what you put into your claims was not new. So, and some patents will break easily and others do not break. When your business is relying on the strength of a patent to gain advantages in the marketplace, knowing if your patent is weak or strong can help you make good business decisions, not waste money on patent battles that you will not win. So, for example, if you're a small business or an entrepreneur looking to protect your inventions, you're going to, or if you already have a patent and you're looking to sue somebody, you want to know, what are the weaknesses in my patent? Instead of jumping into a lawsuit and then having the other side show you your weaknesses. You want to know those up front. If you're a small business owner or entrepreneur looking to protect your inventions, be sure to subscribe to our podcast and book a call with us to discuss your patent strategy. So what makes a patent strong or weak, and how do you see the difference? So patent rights are in the patent claims, and patent claims work where you have a list of either method steps or structure, functional pieces that are together in your patent claim. And this is what the patent rights are. It's what's in that claim. Now, the drawings and the specification, the written description that's not the claims, those are used to interpret the claims, say, what does it really mean? What is this word referring to? But the claims are the heart. Those are the rights. And if what you consider your invention is not in the claims, then it's probably not protected. Now, sometimes inventors think of all the different bells and whistles as their invention, but if they can get a patent on a few key elements, the core or the minimum viable product of their invention, then they have, if they can get a patent on that, then they have a very strong patent as long as it can survive in a patent battle. And it's also good to understand generally what claims cover in case you're either getting into a market and you find there are some existing patents and you want to know if you're going to infringe or not, if you need to take a license, or if it happens that you get a cease and desist letter and there's somebody saying, hey, you infringe my patent. Then you want to be able to, you look, what we do as patent attorneys, and you can do this as well, is you look at the claims first. Sometimes they're really hard to understand. You read the claims and then you don't always understand quite what it means. Even as sometimes us as patent attorneys we're not sure exactly what it means. And we have to look at the rest of the patent to interpret those, to figure out where it's coming from, what it covers. Ideally, it's clear on its own and you don't have to look at anything else to interpret it. And a patent only covers what is in the claims in terms of if somebody has a patent and it's got 5 elements in the claims, then for somebody to infringe, they have to do all 5 of those elements. If there's one that they're missing, then they don't infringe. If they have an additional 10 or 15, but they have those 5, they're still infringing. So that's a critical part, especially if you're looking at somebody else's patent and saying, do I infringe? And of course, if it appears initially that you infringe, there are things that might save you. And we're going to talk about some of those in some of the episodes today. And so reading the claims, and when your patent attorney is drafting your application, you want to read those claims and ask your patent attorney what the claims mean and understand. If you don't understand the claims, then you need to work with your patent attorney to understand that, because that is your legal right. That's the right you're paying for. If you don't protect your intellectual property in the way that you need to protect your business, then you've missed out on potentially the value, and you might make it easy for others to avoid infringement of your patent. So the first thing to make a strong patent is you need a patentability search that goes deep enough to determine whether your invention is eligible for the utility patent. And then you need to discuss with your patent attorney, based on that search, what can and cannot be covered. Sometimes I've definitely had this conversation a lot with clients. There are times when we do the research and I say, well, there are these things that are close. So based on the invention you have right here, you could probably only cover this portion of it. And sometimes the clients will then say, you know what, I think I have ideas to improve on it. And so they go back to the drawing board and they make a better invention, and they actually use the other invention or the other patent that we found and design around it in terms of making sure that their new design doesn't infringe. And then we come out with a stronger patent that's safer. And one of the things to understand is that you can infringe somebody else's patent and still get a patent. So you'll want to work with a patent attorney to draft detailed utility patent application that includes strong patent claims. And as I said, read the claims before the patent is filed, understand them. And claims, one of the other things to understand is your patent really should have multiple claims. And because, as I said, you're preparing your patent for battle. Hopefully it never has to go to battle. But if it does go to battle, they're going to do research. And if you have multiple claims, there are a lot of the claims will be backup positions. So if they knock out claim 1, then maybe they won't knock out claim 2 or 3, and those will survive the challenge. And then you still have something to continue fighting with. The first thing that happens in almost every patent litigation case is the defendant, the person who's being accused of infringement, will do deep research. Like I said, they might spend 100 hours, hire a firm that just does patent research, and they will look for things so they can invalidate your patent, and they'll take it back to the patent office to try to invalidate your patent. And that's where your original claims might not survive, but some of your backup claims. And so to have a strong patent, you need multiple claims, and you need good positions and good research. So what we encourage you to do is book a call with patent attorney Wayne Carroll, that's me, to discuss your patent strategy and start taking steps to protect your inspiration and innovations today. The next episode is about patent drawings and how to avoid costly mistakes.